Hello, and thank you so much for attending the Type 1 Summit for Diabetes and Me. Thank you so much, Kristen Bienstock, for joining us today. Kristen is a lawyer, and she's joined us. She's represented many clients in contested and uncontested dissolution proceedings and domestic violence cases, adoptions, child custody, and child support modifications. In addition to being a Lawyers Fostering Independence, a program for children aging out of foster care systems, she's actively involved in pro bono work for the King County Bar Association, free legal clinics, and family law programs. Over the last 8 years, she's been featured in the top 100 family law attorneys in the state of Washington, and for the year 2018 by the American Society of Legal Advocates. She's also been recognized by Lawyers of Distinction for Excellence in Family Law and Divorce for Law in 2019. Welcome, Kristen, and thank you for being here. I know that you don't really specialize in type 1, but you fundamentally are all about the protection of families and children and rights, and we're so happy that you could be here. Thank you so much for joining us.
Thank you, Alana, for having me. I'm excited to be here today.
So I have a few questions for you, and we'll start off by talking about caring for a child with diabetes requires significant financial, emotional, and psychological resources. The stress can take a toll on a relationship. However, in the case of divorce or shared custody, parent stressors multiply, as caregivers consistently need to transfer supplies and information across household. It goes without saying that both the parents need to stay connected and coordinate, but they should continue to support each other. On some of our boards and across the internet, we've seen that some say that the insured parent feels that the ownership over the supplies lies with them. Is there any truth to this statement?
So typically and I'm speaking in generality, just in items that go with children. So the court typically believes that just items in general, whether they're insured items, as you just asked, or just items in general, speaking more generally, clothes, tablets, etc., the courts generally believe that those items move with the children. So parenting plans are something that can be crafted to fit each individual family, and that's what the courts believe that they're there for. And each family is specific to themselves. So when crafting a plan, let's say, for example, when a parent or family is divorcing and those children or child at the time, let's say, isn't diagnosed at that point with diabetes. And so they don't have to craft that plan specifically, to transfer all of the items that you're talking about that the insured parent has to specify within the parenting plan. They can always go back for what's called a modification and then specify within the parenting plan how the items are to transfer with each individual child.
Okay, so it sounds like the child, it's always in the best interest of the child. So it doesn't matter who's insured, that the supplies that take care and keep this child alive should always be with that child, regardless of who's insured.
Absolutely. And you're correct. The standard that the courts utilize is best interest of the child standard. Whether or not that's always followed is another area for us to get into, but I don't believe one to delve into today. But that is the general standard that the courts go by, which is best interest of the child. And items that belong to the child should transfer with the child from home to home.
Okay, thank you for clarifying that. So, in most homes, whether they're, married or single or dating or whatever the situation is, there generally tends to be what I call a primary pancreas parent, which is the one who does more of the day-to-day tasks regarding the child's medical care. Some families are very lucky and they've been able to divide up the tasks, but generally there is, somebody who does most of the tasks. It is statistically pretty rare to have equal division of tasks. What advice would you like to share with families with shared custody of children with medical conditions? If one parent is not capable of providing proper medical care and the child consistently comes home with ketones or added stress because the secondary home isn't adapting or is in denial of the diagnosis, so the kid continues to come home sick because the secondary home maybe isn't providing that same level of care that the first one is, what would you advise?
So in situations like that, I guess I would need to meet with those people who are having these situations where that non-primary pancreas parent that you just mentioned, and the other parent isn't following, what is in the best interest of this child, and this child's coming home sick, et cetera, not following the medical instructions that this child needs, that may call for what's called a modification of the parenting plan. But it's also case by case specific, and I would need to look at that party's or that parent's parenting plan specifically, because when initially drafted the parenting plan, when those parents initially drafted the parenting plan, there are specific provisions in a parenting plan that, I could give generic advice, but there's provisions that are in there, whether or not they have a mediation provision, other provisions that are set in there. So I can give very generic advice today, but again, it's hard for me to give definitive advice without meeting with people in a consultation and looking at their actual parenting plan to give them solid advice. And I hope that makes
Right.
sense.
Right.
But it would be probably, again, generically, either a mediation route and or a modification of the parenting plan, which I just want to say modifications in Washington state are very difficult to do. But it's, from what I'm hearing, if a child is getting sick and not following the other parent's not following the instructions, a modification may be the route to go.
Okay, so it sounds like there are options, because obviously the situation become quite nerve-wracking if a parent isn't fulfilling his or her caregiving responsibilities. But it sounds like there are options. There's actually two options in this scenario to promote collaboration with a co-parent. So they
Right.
can either, do the modification
There's
or,
definitely always options. And again, dependent upon each party's particular parenting plan, there may be more options. But off the top of my head, those are the two, generic options that I can think of without seeing each party's particular parenting plan that they have and history of the case.
great. Thank you. So we talk about it takes a village to manage diabetes, and we like to think here that we have a very strong community. Obviously, the more fortified the village, the better it is. Studies have shown that the more love and support the children get, the better they cope. How does the role of extended family come into play with shared custody in terms of visitation rights for grandparents or caretakers? Does it differ if there's a medical situation, or if you wanted to build something in or not? If you have concerns with their, medical care, can you stipulate if, people need to have some sort of understanding of medical care for the child?
So I'm not really quite sure I understand your question on stipulate for medical care. Can you maybe expand on that a little bit so I can answer that better?
Yeah, so I guess what I'm saying is that, obviously you want to have as many people as possible taking care of the child.
Sure.
But at the same time, you want to make sure that everybody knows what they're doing, and is safe when they're not under your care. So when the child isn't in your care, is there any way to add that into this plan of saying that anyone who, once the child is out of your care, does have to have a certain level of understanding of their health management or their diabetes care?
Sure. So a parenting plan is specific to each particular party, and it can be tailored and drafted to each particular situation, as you've just mentioned. So let's say, for example, you have an aunt or a close neighbor, what have you, a grandparent, who is part of your village and helps to take care of your type 1 child. And they have the medical information to help care for your child. They've been to classes or whatever, and that person is a good support, and you can draft that person into your parenting plan. That's absolutely acceptable to the courts, as long as it's something that suits the best interest of your child or children. There is a new law that came onto the books about a year ago. It's called the Relative Visitation Statute, but that is to gain visitation, not custody, but visitation. It doesn't sound like that's what you're asking of me right now, but that's when both parents are, not allowing a biological or married in type of relative, grandparent or otherwise, and there's specific factors they must follow to gain rights through the court to have actual visitation.
Oh,
But but it doesn't sound like that's what you're asking. But there are options, but that's more of a visitation type of a procedure.
Okay.
Can build in um, aspects into your parenting plan, because no parenting plan is going to look the same, and especially when you have a particular situation as you're describing with these children who have type 1, you're going to want your parenting plan to be tailored specifically for these children.
Okay, great. And having that extra information and knowing about new laws is obviously an important factor. I would assume when you're selecting somebody to help you with your parenting plan, that isn't even something that I would have known to ask. So thank you for sharing that information. I say that's really helpful. Um, so when it comes to shared custody and medical appointments, some families on our boards have asked, do they have to bring the other along? Because how else would they know anything about caring for the medical needs of their child? Um, you know, how does that work? You know, what do you suggest? Does this all of a sudden means that you have to, get along in order to go to these medical appointments, or what are your suggestions when it comes to, medical appointments and care for the child to make sure that everybody knows how to take care of this child?
So a lot of the time, you're divorcing, and a lot of the time the people are not getting along, and it's acrimonious, and the two parents can't sit in a room and the child is there, and you don't want your child to be involved in that situation. So I personally, from my own personal experience and professional experience doing this for so long, I don't know that I would necessarily recommend to parents who don't get along to be in the same room in a doctor's appointment. What I have had clients do is a host of things, either switching off, right?
Okay.
One parent take this time, another parent go the next time, and then share, the chart notes or the discharge paperwork that you get. One parent can go to the appointment and the other parent can call in on speakerphone and listen in, so they're getting the same information as the parent who's taking the child to their doctor's appointment. There's also some apps that are available now. One of them is called Our Family Wizard, which you can share. It's an email program. It's also a calendar program, and you can share everything on this program. It's also can be looked at by your attorneys, the courts, and so it's a little bit more peaceful than a typical, Gmail program, but you can also share the chart notes through there, and you could see when a parent has read it and stuff like that. So those types of things are also very helpful. And again, they're monitored programs. And so if you're sending an email with some nasty words before you hit send, it kind of warns you that you might want to rethink the words you're writing. And that's also very helpful. I know it sounds silly, but you're in these situations and it's kind of helpful. So that's what I found to be helpful, is either a rotation of the parents, taking the children, sharing the notes that the doctor gives at the end of the appointment with the other parent, or the other parent calling in, at the same time of the appointment.
Okay. I think that's helpful, maybe even for parents where the other parent, in married situations where the other parent can't even attend. So thank you. I think that's actually really helpful
Yeah.
for, any family to have that tip. So that's actually a really helpful tip. So thank you so much for that information.
Yeah.
um, um, so my next question is with regards to judges. And when I was thinking about, what questions to ask, I was thinking about that I couldn't expect judges to be aware of the delicate intricacies of type 1 or any other chronic condition for that matter. So how can we ensure that the court will keep the child's best interest in mind when it comes to dietary requirements or medical administration or glucose monitoring or all the other details when it comes to making final decisions?
So that's a great question. So I'll start by saying you should never get to a judge. I want to preface it by saying no case should ever go to trial. 95% of the cases do not get to trial. But if you are one of the cases that does get to trial and does get to see a judge, they're very expensive and you are fighting, right? You're not going to like your ex at that point in time. But if you do get there, you're going to have to hire some experts and you're going to shell out some money, right? I mean, trials are very expensive, and you're right. The judges don't know anything. So you have to teach the judge in, a week's time, everything about your case, everything about your child, and the nuances that go along with your child. And so whether it's hiring an expert to teach the court about what type 1 is truly about, the dietary issues, the stuff that goes along, with the going back to the first question, with the stuff that goes with the insured parent and all of the stuff that belongs to the child. You're going to have to teach the judge, just as you were once taught as a parent, finding out your child was diagnosed. You're going to have to do the same thing to the judge in a few hours. And whether that comes from an expert or your child's doctor, that's the situation you're going to be faced with in a trial situation.
Oh,
Yeah.
Interesting. So then before it goes to court, there's a mediator, right?
There
Okay.
is. And you
So-
don't necessarily have to, and I don't mean to cut you off, but if you guys can, you start a case and then you kind of are in this, filing land. And some people go for what are called temporary orders. And then you see what's called a court commissioner, and they give you these temporary orders. And then from there, you will either come up with agreements on your own. And if you cannot, then you're required to go to mediation. And then the majority of the cases, I would say 99% of my cases, settle in mediation. And you should settle in mediation because it gives you as a parent some say in how, depending on how old your children are, but the rest of their lives are going to be, and your life gives you some say. And you go to mediation and hopefully you settle. And then you and your ex are in 2 different rooms and with your respective attorneys and or support people. You guys don't see each other because it's a very emotional, very highly, charged atmosphere, but you guys are in 2 separate rooms. And for the majority of the time, it works. It settles. God forbid it doesn't, then you're faced with that situation I just told you about with the judge.
Right. So you're obviously looking for a neutral mediator to be appointed to establish mutual expectations and follow through with the diabetic care regimen. So who appoints that mediator and how does that work?
Yeah, so a mediator is not appointed. It is somebody who is selected by each attorney. So the attorneys will, go back and forth, and, there's really great mediators out there and there's also not so great mediators out there. And so dependent upon who your attorney is, they should hopefully know who's good, who's bad, and who would be, who would be good for your particular case. Sorry, I'm having computer yeah, so hopefully you should select a good mediator based upon, the trust you have in your attorney. And I don't know what's going on.
If you want to stop talking until you get it adjusted, we could just cut that in. Get adjusted.
Okay, hold on. I don't know how to work this.
Because all we see is your chest right now.
Sorry.
I had the same thing happen to me. My computer fell right off the table.
I don't know how to work this thing. Darn it. Okay.
I only have like 1.5 more questions to put on your knees. Oh, there you go. That's
okay.
So did we finish that question? Do you want me to ask again?
I think we finished it.
Okay. All right. So my next question, and I don't know if this is a silly one, and maybe it's just because, my kids have had situations where they have to miss school or be excused from school due to illness or for particular services like having to go to, every 3 months they have doctor's appointments, or sometimes there are other issues like medication administration, or if they have special education in addition for additional issues outside of type 1. But are both parents able to grant permission for their child to be excused from school or for particular school services once, this happens? Or
so in the parenting plan, there is decision-making authority, and the 2 common decision-making authority provisions are medical decision-making, and that's non-emergency medical decision-making, which is what you just explained, or education decision-making, which is not necessarily what you're talking about, even though
that one of them was.
Right. Well, the medical decision-make, or the educational decision making goes into more like what schools are they going to be going to. So it doesn't really dip into the situation you were discussing, even though it touches on education. So it's kind of a little different.
But it sometimes can play a role because actually, unfortunately, sometimes more than we like to think about, some schools aren't necessarily equipped while it's illegal to handle type 1 students. And I hate to even articulate it and say it out loud because we don't like to think that it happens, but it does happen. So sometimes school decisions have to be made outside of the regular standard district that you were planning on going to. So sometimes that does happen. So let's talk about both of them.
So in a parenting plan situation, this is something that I would already anticipate happening during the drafting of the parenting plan. And so I would bake that into the parenting plan ahead of time, even though if you don't necessarily encounter that situation. I would bake it into as a provision that whether you want it to be either parent or only the mother can, or only the father or both parents, you can make it a subdivision of the parenting plan in a section. Now you might have issues with the Becca bill because that becomes a problem, and that's not something you can circumvent, right? Because those are state procedures that a parenting plan can't get you out of.
And what is that? Sorry.
So the Becca bill is when your child becomes absent a certain amount of days in I guess a semester or a quarter, then they will be sent for truancy. It's a truancy bill. But I believe if you are on the up and up, so to speak, and you clear things with your children's doctors and
if you're protected under a 504 plan
or an IEP, and you also get your child's doctor to write some type of a doctor's note that it's a medical necessity, and you turn it into the Becca coordinator for your school district, that should cover you. And therefore, because your child isn't really truant, and they won't then be turned over to truancy and then go through that whole court procedure. So just something to kind of look out for.
Okay. Just to wrap it up, I'm actually curious about this one. Are medical expenses factored into child support? Is it generally done for families, or do type 1 families need to get specific on this one since our costs are pretty high generally in comparison to others?
So medical expenses are factored into the order of child support, and it's usually based on a proportional share. And that's based off of, how the parents are paid. And it's case by case specific because it's a whole formula that's done on the child support worksheet. And it's, you plug numbers in, you push a button, and it's formulaic. It's, it's a statutory system for child support. And then, you push a button and it generates these numbers, and then a percentage comes through these numbers. And uninsured medical expenses are paid typically through a proportional share, whether that's 60-40, 70-30, some uneven numbers, unless you agree otherwise. You can always agree otherwise, but statutorily it is usually split per the proportional share, those uninsured medical expenses. That's typical. Yeah.
Okay. So that you have provided a wealth of information. Obviously, we hope that people don't need to get into the situation, but it's the harsh, reality of today's world. And so, I want to thank you so much for sharing this information with us. If our audience wants to learn more about you and your work, how can they connect with you?
So they can always call my office, and or emailing me is always the best way, so I can be the most responsive. I'm not always in my office because I'm in court or at mediations, and I offer free consultations, and I'd be more than happy to help any way that I can.
Okay, so on your under your video page here, there'll be a link to your website, and that's the way they'll be able to contact you as well. And then for the legal spiel, I guess we're going to say that we want to remind our audience that this should not be considered legal advice. It's intended for general information only and not to specific or any particular case that has been brought up, and that they should always consult with an attorney who may be able to provide information that is commensurate with better understanding of your full particular situation. So if that is the case, please reach out to a lawyer, whether it be Kristen or somebody else in your area. But we hope that you've enjoyed and or learned something from our talk today. So thank you so much, Kristen, for joining us today. We really appreciate it. Thank you for coming.
Thank you.